Good morning, Mr. Lewis. I can see your coffee mug and your countertop, but I can't see you. Are you available? Good morning, Mr. Lewis. So I would like to begin since all our panel members are here. Good morning and welcome to this online hearing of the Committee of Adjustment of the City of Ottawa under the Planning Act. This video conference is also live streaming on YouTube. With me are my fellow panel members, Jocelyn Chandler, Stephen Lewis, Terrence Otto, and Martin Vervoort. My name is Fabian Poulin, and I will be chairing this hearing today. The procedure for this hearing will be as follows. Listed on the agenda and appearing on the screen are applications we will hear today. For the sake of efficiency, the committee may deal with agenda items in a different order. Committee members have reviewed the planning reports and any written submissions in support or in opposition of each of the applications. Today, we'll hear oral submissions from any interested parties. Notice regarding minor variance applications, notwithstanding pre-consultation with city staff, is the responsibility of the applicant to identify all required variances accurately on the application to 1, add a new variance, or 2, to increase the extent of the variance requested. This must be given in accordance with the Planning Act and may require the application to be recirculated for the next hearing date at a cost to the applicant at the prescribed fee. If an applicant amends their plans with no impact to the variances or to reduce the variances requested, recirculation may not be required. As part of the statutory notification requirements, each applicant was required to post a sign on the property and file a statutory declaration confirming the sign posting. This declaration must be on file today before we can hear the application. Without it, I may have to adjourn the application or administer an oath if necessary. Can the coordinator confirm that we have received all statutory declarations?
Mr. Chair, we have not received any statutory declarations. The oath will need to be read for all items.
Thank you very much, Madam Coordinator. The committee may ask for a brief presentation of the application, followed by questions from members and submissions from the public. Please address your comments to the chair, starting with your name and spelling it if necessary, and your municipal address for the record. The committee limits presentation to 5 minutes. Any exceptions will be at the chair's discretion. Before we begin, we don't have any minutes to adopt. However, I would like to ask the panel if they have any declarations of interest on this or any other committee panel. There are no declarations of interest. We will now hear the application scheduled for this hearing. We'll deal firstly with any items that may be adjourned. I believe we have several that would like to be adjourned today, and beginning with, I believe, number 6. This is having to do with 199 Langstaff. Number 6. Is Ms. Libman available? I can see your name. There you are. Good morning, Ms. Libman.
Good morning.
I understand you have an adjournment request.
It's actually a request from staff, but we are in agreement with the request.
Okay. And you would like to adjourn at sine die?
Yes, please.
Okay. I'd like to ask the panel to adjourn this application sine die. All those in favor, please raise your hands. Your application is adjourned sine die. Thank you very much, Ms. Libman.
Thank you. Take care.
Thank you. Now, items 9 and 10 are the next items up for potential adjournment. And this is having to do with 7901 Mitch Owens Road. Mr. Poulton, are you available?
10 and 11, Mr. Chair.
Sorry, you're correct. Sorry, 10 and 11. Mr. Poulton, are you available?
Good morning, Mr. Chair.
Good morning. I understand that you would like to adjourn this application sine die. Is that correct?
Yes, we would like to adjourn at sine die.
Okay. So all those in favor of adjourning this application sine die, please raise your hands. The application is adjourned sine die. That's both 9 and 10, or 10 and 11, excuse me. Thank you.
Thank you.
Okay, so. And we have application number 7. I'd like to read into the record that this is for 100 and 102 Constance Lake. And this application has been withdrawn by the applicant. And now we'll move on to the items in order, beginning with application number 1. Application number 1 is having to do with 2164 Old Birch Road. Mr. Price, you are the agent on file for this application. Are you available, sir?
Good morning, Mr. Chair, members of committee. Rod Price, Wartar Land Development Consultants. Sorry, as the coordinator was letting me in, I missed which application number 1 is.
Application number 1 is having to do with 2164 Old Birch Road.
Thank you, Mr. Chair.
Thank you. I would like to administer an oath concerning the signposting. Can you take that oath today?
I certainly can.
Do you solemnly swear or affirm that the notice provided by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing and as instructed and was clearly visible and legible during that time? Do you swear?
I swear, Mr. Chair.
Thank you very much. So now, would you give us a brief description of your application, sir?
Certainly, Mr. Chair. As I mentioned, Rod Price, Wartar Land Development Consultants, on behalf of the owner for the submission of the creation of a new rural lot, about 5 acres in size. Pretty straightforward. We've provided MDS calculations as part of the application. I have gone through staff's report and are okay with the suggestion in terms of where we'll locate the entrance. Pretty straightforward one. So if committee has any questions, happy to answer.
Okay. Are you aware of the 7 conditions should this application be approved? And you agree?
Reluctantly, yes, as always, Mr. Chair, for the record, I do object to the amount of road taking, but you know, it's a small rural landowner and he'll accept the condition, but it's just a matter of principle for me that I'll continue to make that objection.
Okay, thank you very much. Mr. Kukkonen, do you have any comments on behalf of planning?
Good morning, Mr. Chair. No further comments at this time. The additional condition for the road entrance is just to highlight our concerns with the water course running adjacent to the property in the ditch, but we feel confident that this condition will satisfy our concerns with that.
Thank you, Mr. Kukkonen. Thank you. I'd now like to ask our conservation partners for any comments they may have. No comments? Okay. So we will now move on to our panel. I'd like to ask the panel for approval of this application with all 7 conditions. All those in favor, please raise your hands.
Mr. Chair, I think just for the record too, we just have to amend the notice. It should say a frontage of approximately 600 meters on Old Birch Road instead of 477.
Yes, my apologies. Thank you very much for that, Mr. Ward. So are you in agreement with that, Mr. Price?
That's fine, Mr.
amendment
Chair,
should-
yes.
Okay, thank you. We'll amend that part of the notice. So again, all those in favor of this application with all 7 conditions, please raise your hands. Your application is approved, Mr. Price. Thank you.
Thank you, Mr. Chair.
Now moving on to application number 2. This having to do with 2348 Dunning Road. Mr. Luke Laundrie, are you available, sir? Good morning, Mr. Laundrie. I can see your name, but I can't hear you. You're muted now. Hello?
Here.
Good
Can you hear
morning.
me now?
I can hear you now. Thank you very much. I'd like to administer an oath concerning the sign posting on your property. Can you take that oath today?
Yes, I can.
Do you solemnly swear or affirm that the notice provided by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing as instructed and was clearly visible and legible during that time? Do you swear?
Yes, I swear, Mr. Chair.
Thank you very much. So I note that there are a few items we need to address from the notice, and the following items need to be changed. And I'm going to ask you, Mr. Landry, if you agree. The severed lands will have a frontage now of 11 meters on Dunning Road. Is that correct?
That is correct.
And a depth of 275 will contain a lot area of 0.86 hectares. Is that correct, sir?
That is correct.
The retained lands will have a broken frontage of 839 meters. Is that correct, sir?
Correct.
And an area of 63 hectares.
Yes, approximately 60. Yes, thank you.
Great, thank you very much, sir. So I understand there was an adjournment request by the planning department, but I believe that's been revised. Is that correct, Mr. Harrigan?
Thank you. Through you, Mr. Chair, that is correct. The planning department had some initial concerns that about a full hectare of prime agricultural farmland was being fragmented with the severed lot. These revised lot lines completely address those concerns. And we just note now that the southern interior lot line was originally proposed because that's where the hydro poles were in the hydro connection. So we've had the pleasure of working with Mr. Landry to revise the proposed lot line configuration, and then also add in an easement condition just to address those hydro poles there. So the planning department no longer requests any adjournments, and we have no concerns with this file, subject to the requested conditions.
And there are 7 conditions, Mr. Harrigan?
Yes, there are.
Great, thank you very much. I also note for the panel, for the panels that the conservation partners do not object to this application either. So to that end, I'd like to ask the panel for approval of this application. All those in favor, please raise your hands.
Mr. Chair.
Mr. Chair.
If Mr. Landry is in agreement with the conditions, and I believe there was some discussion of condition number 7 regarding the hydro easement.
Mr. Landry, are you in agreement with those 7 conditions?
The condition number 2 of the city requiring a road of frontage, the owner is not in favor and would like the panel to, Mr. Chair, to remove that condition. To have a surveyor of 1.2 kilometers in length is excessive, as per previous discussions with other agents in the last few months. So they would like to remove that condition.
Okay, do you have a comment, Mr. Harrigan?
Thank you. The planning department will object to this application with this removal of this condition. This is a black and white official plan requirement for every single severance that occurs in the city of Ottawa. Removing this condition is not fair to any of the other applicants who adhere to this requirement. This requirement applies equally to every single severance application, whether in the rural area, the urban area, the villages, anywhere else there. It is not fair to arbitrarily decide that it's too long and then therefore it shouldn't apply. City infrastructure, it requires a significant amount of investment to have city infrastructure in the form of roads extend out to these properties. This property is benefiting from these city infrastructures, the over kilometer of road frontage, it has benefited from that. And this application should be to the benefit of that city infrastructure. Road widening, road maintenance, road widening, anything that could occur in the future for road enhancement or just maintenance can be an exceptionally costly item for the city. And taking these road conveyances, which is the only time we possibly can take this road conveyance on this property, saves a considerable amount of money for the city and could mean the difference between enhancing 5 roads or enhancing 1, because they have to do all the expropriating and the legal costs associated with taking the land whenever they do go into a future road widening. It's a black and white requirement that's required for every single application in the city, and it's not fair to remove it for applications because they retain land slightly larger than what is normal in the urban area. It applies equally to everyone, and we will recommend refusal of this application without this condition. Thank you.
Thank you, Mr. Harrigan. Any further comments, Mr. Landry? Any further comment, Mr. Landry?
No, we understand the city's position, but 1.2 kilometers of surveying is excessive, and I think this has been raised in the past.
Yes, it has. Mr. Lewis, you have a comment?
Yeah, I appreciate Mr. Harrigan's new and lengthy spiel. It's a changed story from before. I appreciate that. But if Mr. Landry doesn't want to put the road condition on, I'm 100% in support of him if he doesn't want to do that. It's his decision. I'd like to see it'd be great to see where this goes.
Mr. Landry, so you know that when the city they've informed the committee that if someone wants to object to this condition, that they will appeal it, and this will extend the time that your client will be able to get approval of this application. So it will delay the development of your property. Mr. Harrigan, you have pardon me? Sorry, Mr. Landry.
Yes, I'm aware there would be some delay.
Okay, thank you. Mr. Harrigan?
Yes, thank you. Just two comments. The first is just in the comment of the surveyor costs associated with it. They have to already mark the corners of the property. The surveyor has to go out and measure the full kilometer, and it's just a matter of measuring that extra 2 meters of width and placing another post side by side where the edge of the property line was going to be. So the cost with it isn't significantly larger than what would normally be associated with it. And again, this is an official plan requirement that's applicable to every single application. I would ask that the committee keep this application imposed, and if Mr. Landry and the owner want to have it removed, that the onus of an appeal should be on the applicant for this application. As it says, it's a black and white official plan policy at this point.
Thank you, Mr. Harrigan. Now I'd like to ask the panel for their comments. Mr. Vervoort?
I agree that we should impose the condition. I think that battle's been lost, unfortunately. And if Mr. Landry's not satisfied with the condition, it would be open to him to file an appeal and let the appeal tribunal deal with it. I would also comment on condition number 7. I think there was some correspondence with legal department on that. And they indicated that it may not require an easement from one owner to another, but the condition should rather read that the owner ensure that the separate parcel is adequately serviced by hydro.
Thank you, Mr. Ward. Mr. Otto, any comments?
Well, we've always asked the applicant before whether they review this, and everybody so far, in most cases, has. I agree with Mr. Lewis that if the applicant wants us to turn it down, we should remove the condition. Or I guess as Mr. Vervoort suggested, pass it with the condition in and the applicant can appeal it. Either way, I think it's time for this to come to a head.
Thank you, Mr. Otto. Ms. Chandler, any comments?
I would just reiterate Mr. Vervoort's position.
Thank you. All right, so I would like to now ask the panel to approve this application with all 7 conditions intact. And this will allow the applicant to make application to appeal on the road widening issue that he feels strongly about. So to that end, I'd like to ask the panel for approval of this application with that change. All those in favor, please raise your hands. So there's 3.
Just to be clear, Mr. Chair, you said with that change.
So just that the applicant may be able to do his own appeal, because we're not leaving it in the hands of the owner. Sorry,
I think there's
of the
no
city.
change then.
Correct. Sorry. Yeah.
Except for condition number 7, right, with the hydro.
Right.
Yes, the hydro. Yes, Mr. Lewis.
Just, I want to just in the I support the application. I just don't support the road widening clause. So if you put me as not supporting, it looks like I don't support the application. I support the application, but I do not support the road widening.
Okay. Mr. Otto, would you like to have that same caveat? Okay.
Please.
Okay.
Yes,
So Your application is approved, Mr. Laundrie, with all 7 conditions, with the modification to number 7 having to do with the hydro pole easements that Mr. Vervoort suggested. And we'll note that Mr. Lewis and Mr. Otto both support the application. However, they do not want to have the road widening condition imposed on the retained lands. Thank you very much, Mr. Laundrie.
Thank you. Thank you.
That's number 2. Now we'll move on to application number 3. Number 3 is having to do with 3561 Donnelly Drive. Douglas Milne Smith, are you available, sir? I see a Michael Filardo. Are you representing?
Good morning, Mr. Chair. Yes, I am.
Okay.
I'm here also, but I guess you can't hear me.
Okay, now I can hear you, Mr.
Thank you.
Smith. I can.
Yeah.
Who is able to take the oath concerning this property for the signposting?
I am.
Okay. Mr. Milne Smith, do you solemnly swear or affirm that the notice provided by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing as instructed and was clearly visible and legible during that time? Do you swear?
I do.
The panel notes that planning and conservation partners do not have any objections. However, there are 7 conditions if this application is approved. Mr. Milne Smith, do you agree with those 7 conditions?
Mr. Chairman, I do not have a copy of the conditions. I never received any email. I'm hoping Michael Filaro has them, but nobody sent me any conditions that I'm aware of.
Mr. Filardo, did you get a copy of the conditions?
Mr. Chair, the only email that we received was that of Mr. Jones with the conservation and hydro comments, but no, we have to date not received any conditions.
Okay, Mr. Kukkonen, can you tell us about the conditions required for this application if it's approved?
Yes, through you, Mr. Chair, I can. I will just go through the conditions quickly here. Bear with me for one moment, sorry. So condition number 1, that the owner enter into an agreement with the city at the expense of the owners and to the satisfaction of the development review manager of the relevant branch of planning, real estate, and economic development department and his or her designate, which provides the following covenant notice that runs with the lands binds future owners on subsequent transfers, that the city does not guarantee quality or quantity of the groundwater.
Do you agree with that, Mr. Milne Smith?
Yes.
Okay, go ahead, Mr. Kukkonen.
Similar to that condition, that the owner enter an agreement with the city at the expense of the owner to the satisfaction of the development review manager of the relevant branch of planning for the covenant or notice that runs with the lands and binds future owners on subsequent transfers, that the city of Ottawa has identified that there are potential and inferred karst topography, sensitive marine clays and soils, and thin soils that are within the area and may require site-specific geotechnical engineering solutions to allow for development. The city of Ottawa bears no responsibility, financial or otherwise, to provide solutions to the deficiency.
Do you agree with that, Mr. Milne Smith?
Yes.
Mr. Kukkonen?
Number 3. Sorry, thank you. The owner convey, if required at no charge to the city of Ottawa, sufficient frontage across the severed and retained lands to provide for a road right-of-way measuring 15 meters from the center line of Donnelly Drive.
Do you agree with that, Mr. Milne Smith?
Yes.
Mr. Chair, if I may.
Yes.
And through you, Mr. Chair, and Mr. Kukkonen, it's my understanding that part of an existing easement that was registered in favor of the city of Ottawa, that a road allowance has already been, a road widening has already been taken. Is it possible to have that condition stricken if that's the case?
Yes, if a surveyor can confirm that is the case, then that would be sufficient.
Very good. Thank you.
Next, Mr. Kukkonen.
Condition number 4, that the owners provide a report to the satisfaction of the City of Ottawa, demonstrating the adequacy of the aquifer with respect to the quality and quantity of water to support the proposed development.
Do you agree with that, Mr. Milne-Smith?
Yes.
Mr. Kokonen, next. Cash in lieu.
Yes, pardon me. That the owners provide evidence payment receipt to the committee that payment has been made to the City of Ottawa cash in lieu for conveyance of parkland or other public recreational purposes.
Thank you. Mr. Milne-Smith, do you agree with that one?
Yeah, I agree with it. I'm just trying to think. Mike, can you actually talk to that? Michael?
Yes, pardon me. I just our client did have a question or a concern with regards to the cash in lieu. We understand that is part of the bylaws and that it is required. However, his question was more with the cash in lieu for parklands, rural Ottawa, and there not being any parks in the vicinity. Is it really necessary to have this provision in part of the severance application?
Mr. Kokonen?
Through you, Mr. Chair, yes, it is standard practice that all severances go through this cash in lieu process for parkland. Pardon me. It is standard, and it is to enhance parks in the rural area. We do receive cash to enhance these parks as that is the standard process through the bylaw. Mr. Harrigan, if you'd like to give a further explanation on that, if there's anything I missed.
Mr. Harrigan?
Thank you, Mr. Kokonen and Mr. Chair. Through you, Mr. Chair, Mr. Kokonen did summarize it quite well. The cash in lieu is required for all consent applications across the city. In the rural area, that is true that there is less parks that are there, but there are still parks and parks facilities that are in the area that the new lots would have the right to. Just thinking like baseball diamonds, soccer facilities, sports complex, any like hockey arenas that are in those areas. A lot of these cash in lieu park requirements is to contribute towards that. They are adding to the density of this area, and this is a one-time fee to accommodate the future parkland needs of these future residents. So it is required under the bylaw itself.
Thank you, Mr. Harrigan. Do you agree with that, Mr. Milne-Smith?
Yes.
Okay. Item number 6.
A
Sorry?
farm. Yeah. Anyways, that's fine.
Okay. Condition number 6, Mr. Kokonen.
Condition number 6 speaks to the owners entering an agreement with the city at the expense of the owners to ensure that the existing drainage easement in favor of the City of Ottawa be updated and registered on title to the new severed and retained lands.
Thank you. Mr. Milne-Smith, do you agree with that one?
Yes.
Item number 7, Mr. Kokonen. Condition number 7.
Finally, the owners enter a development agreement with the City of Ottawa that implements the recommendation mitigation measures as described in the environmental impact statement prepared by Muncaster Environmental Planning and requires that all future development on the severed and retained parcels, including private services, be contained to the approved development envelope as illustrated in this environmental impact statement.
Mr. Milne-Smith, do you agree with that one?
Michael, talk on that, or
Beg your pardon?
everything's good? You're okay with that?
Yes. We have no objection to this condition.
Okay, I just want to double check.
Okay, thank you very much. Now I'd like to ask the panel for approval of this application, including all 7 conditions. All those in favor, please raise your hands. Your application is approved, Mr. Milne-Smith. Thank you very much.
Thank you very much, Mr. Chair.
Next on our list is item number 4. This is having to do with 2977 Greenland Road. Natalie Castonguay, are you available? I see a Philip Castonguay, and you're muted. I see Natalie now, but you're muted as well. Good morning.
Mr. Chair.
Good
Sorry for
morning.
the delay.
That's quite all right. Can you take the oath concerning the sign posting on your property today?
Yes,
Do you solemnly swear or affirm that the notice provided by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing as instructed and was clearly visible and legible during that time? Do you swear?
yes, I swear.
So I note for the panel that we recognize neither planning nor conservation has any concerns with this application. However, there are 7 conditions. Are you aware of those 7 conditions, Miss?
Yes, I am.
And do you agree with those 7 conditions?
Yes, we agree with them. The minimum distance separation was sent with the application, but was not received by city planning at the time. So we will resend it. So that condition should have been met by now, but we do agree with all of the rest.
Thank you very much. So to that end, I would like to ask the panel for approval of this application, given that there are no concerns by either conservation and planning. All those in favor, raise your hands. So your application is approved. Thank you very much.
Thank you very much.
Now we'll move on to application number 5. This is having to do with 7237 Malakoff Road. And Mr. Brooks, are you available? Mr. Brooks, are you available? I see a Gail Brooks. And you are muted.
How are we now?
Now you're perfect. We can hear you loud and clear.
Gail just has a different voice.
Can you take the oath concerning the sign posting this morning, sir?
It is Glenn Brooks, and yes, I can.
Do you solemnly swear or affirm that the notice provided by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing as instructed and was clearly visible and legible during that time? Do you swear?
I can. I do.
Thank you. Some modifications to the notice I need to confirm with you. The retained land shall have a broken frontage of 581.27 meters. Is that correct, sir?
That is correct.
Perfect. Thank you very much. I note that the panel recognizes that planning and our conservation partners do not have any comments or concerns. There are, however, 6 conditions if this application is approved. Are you aware of those 6 conditions, sir?
Yes, I am.
And do you agree with them?
Except for the road widening, I do have some concerns which I voiced to this committee on previous occasions.
Now, are you suggesting that you would like to have it removed?
No, I'm just raising a concern that will come later. But I am a little bit concerned on the cash in lieu of parkland. I note that last year, and I'm rounding the numbers, it was roughly 6,100. I note too in 2022, the number I have is 9,200. That's just over 50% increase. Now, if that's a standard city practice, I have some serious concerns. Setting that aside, we agree with the conditions, noting that an EIS is not required for these 2 severances.
Thank you, Mr. Brooks. Mr. Lalonde, you have any comments?
If I may, just through the chair, I don't believe the written comments made it in, but the RECA did not have any objections to the application. Did note that there was a water course going through the retained lands. There's no development proposed there, but any future development, we need to maintain setbacks. The Ottawa Septic System Office provided comments and did not have any objections to the applications as well.
Thank you very much, sir. I'd like to ask the panel for their questions or comments. Mr. Lewis?
Just a question. I've heard this before. Mr. Harrigan, can you sort this out? Has the cash in lieu jumped to $9,000 from 6?
Thank you. Through you, Mr. Chair, Yes, it has. And the explanation for that is the city of Ottawa for the rural area, they have two options for cash in lieu. They can choose to do an appraisal option, which is the standard practice that occurs within villages and urban locations, or to streamline the process, we have made a flat rate fee. This flat rate fee is based on the median sales, so not the average, the median sales of roughly 2-acre lots from the previous year. So the 2020 flat rate fee was just over $6,000 because it was based on 2022 sales, or sorry, 2020 sales. 2020, as we know, was the beginning of the pandemic and how sales dropped for the first 8 months or so and didn't pick up until about November, December. So that was artificially lower than probably what was normal for the years. For this year, for the 2022 flat rate fee, it's based on last year, which had substantially increased. As we all know, the housing market has absolutely skyrocketed, and so that's reflective of those median sales from the previous year. So yes, it has increased 50% for the flat rate fee, but that's because the changing in the housing market is reflective of that.
Thank you, Mr. Harrigan. Yes, Mr. Lewis.
And that took effect January 1st?
Yes, it does. So through you, Mr. Chair, the flat rate fee, it's applicable based on the day before an application was approved. So the day before the decision letter has been sent out is the day which flat rate fee applies.
I'd like to thank you and the city for your noticing the affordable housing problem we have right now. Thank you very much.
Welcome.
Thank you, Mr. Lewis. Mr. Otto, any comments or questions?
No comments or questions. Thank you.
Thank you. Ms. Chandler, comments or questions?
None, thank you.
Thank you. Mr. Vervoort?
No comments or questions. Thank you.
Yes, Mr. Brooks, you have your hand up.
I'm just going to follow the logic that was given about the increase on the cash in lieu. If in fact that's going to be the principle, does that mean that our property taxes are going to jump up because of the housing market has gone up as well?
I'm not sure this forum is able to answer that question, sir.
I fully understand that.
Okay.
But the logic fails to meet the test.
Okay.
Well,
Thank
I think Mr. Brooks should be aware of the previous city councillor that that it depends on the mill rate that's set. And so if the city sets a 2% tax increase overall, then it'll be reflected in a lower mill rate if property values have gone up. So.
Thank you, Mr. Vervoort. So to that end, I'd like to ask the panel for approval of this application with all 6 conditions. All those in favor, please raise your hands. Your application is approved, Mr. Brooks. Thank you very much.
I appreciate it. Thank you.
Now moving on to application number 8 and 9. 8 and 9 is having to do with 1268 Carp Road. Mr. Robinson, are you available?
Yes, I am. Good morning, Mr. Chair.
Good morning. Can you take the oath concerning the sign posting on your property today?
Yes, I can.
Do you solemnly swear or affirm that the notice provided by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing as instructed and was clearly visible and legible during that time? Do you swear?
I do swear that to be true.
Thank you very much. I note that, or the panel notes that planning department and conservation partners do not object to this application and have no concerns. I have, however, note that there are 10 conditions if this application is approved today. Do you agree with those 10 conditions, Mr. Robinson?
I do, but I have some points I want to bring up when it comes to that, and they would be in relation to condition 3, 9, and 10.
Okay, well, we're ready to hear them if you'd like to give them.
Condition 3 is talking about a road widening. It seems to be the theme of today's meeting. The ultimate right-of-way width of Carp Road is 23 meters. So city requirements require in severance applications that both the severed and retained parcels provide the requisite road widening in order to meet that requirement. Our understanding in my measuring and scaling off from the survey plan is that currently the distance between the front lot line and what is shown as the crown of the asphalt on Carp Road itself is approximately 13 meters. And certainly we have 11.5 meters existing. So I don't believe it's going to be required. I just want to note that. I have spoken to Mr. Harrigan about it, and he acknowledges that. And he indicated that as one of the condition, in order to fulfill the condition that our client surveyor will need to liaise with the city surveyor to ensure that that is the case. So that's that item. Condition 9 is asking for a joint use and maintenance agreement. My experience on those has been that those have only ever been required when you have, for example, in a semi-detached building or townhouses, where you have a party wall between units, or a common roof, the maintenance of a common roof, or a common fence along the property line. And in this situation, we have neither. So when I saw the condition about a joint use and maintenance agreement, that raised a few questions in my mind as to if this is really necessary. And that's up for discussion. And the last one, condition 10, I understand the reasoning behind asking for some tree planting. I just wanted to confirm that it can just be shown on the site plan. I have discussed it with Mr. Harrigan, have no issue about the caliper, and to locate it either on the front lawn or on the right of way in front of the units. But I don't really see the need to get a landscape architect involved to spec one tree for this. So those are the things I wanted just to raise in terms of the conditions. Otherwise, we're fine.
Thank you very much, Mr. Robinson. Mr. Harrigan, can you comment with respect to those 3 conditions and any modification you suggest?
Certainly. Thank you, Mr. Chair. Through you, for condition number 3 for the road widening, it does appear that it may already be met at this case. It just needs something that has to be confirmed through a surveyor. Geo Ottawa can be a little finicky with these measurements and the lot lines not lining up exactly where they are. So we would just ask that on the surveyor, just confirm that with the city surveyor so that we can resolve that, but that condition should be very easy to clear if that's already met. As for condition number 9, the department's concern with that was really just to ensure that the shared driveway, that the obligations between the 2 property owners is just clearly set out in writing in an agreement that just states who's responsible for construction, maintenance, operating costs, something to that note. So if it is agreeable with Mr. Robinson, we would be okay with modifying the joint use and maintenance agreement to a standard easement agreement, if that is more agreeable. Perhaps the condition could read enter into a joint use, maintenance and operating agreement or easement agreement. So it gives that flexibility for the applicant to pursue either one. But I would assume the easement agreement would be easier for Mr. Robinson and the client. So we are agreeable to an easement agreement for that, as long as it sets forth the obligations for construction, maintenance, and operating costs. As for condition number 10, I do believe that would be appropriate to be shown on a site plan, but it would have to be to the satisfaction of the infill forester. So it would just be, they would have to confirm if the width of the grass planting is sufficient for the trees that are being proposed. So I do believe that this won't require a landscape architect, as it's not written in the condition that it requires a landscape architect. But again, it really depends on where the trees are initially proposed, and if there's no concerns, it can just be shown on a site plan. If there are concerns about having sufficient grass or soil volume for the tree, then they may ask for additional information, but for the most part, it should be fine on a site plan, and just for the client or Mr. Robinson to complete that.
Thank you, Mr. Harrigan. How does that work, Mr. Robinson?
Those are fine. The condition 3, Mr. Harrigan sort of summarize. Condition 9, we'd like it to say a joint use and maintenance agreement or an easement agreement. Mr. Harrigan and I spoke about this yesterday afternoon, and as well, condition 10. Since these 2 triplexes do not require site plan approval, which is usually a trigger for requiring a landscape architect, we'd be fine with it just needing to be approved by the infill forester, and it can be shown on the site plan, and we can work with the infill forester for that. So we're fine with those modifications.
Thank you, Mr. Robinson. I'd now like to ask the panel for approval of this application with those 3 conditions amended, the 3 of 10 conditions amended. All those in favor of this application, please raise your hands. Did I see your hand raised? There. Do you have a
Do
comment,
we
Ms.
not
Chandler?
have some public comments on this application to hear?
I don't think we do have this one, and we have one soon.
Okay, sorry.
That's okay. So to that end, your application is approved, Mr. Robinson. Thank you very much.
Thank you. Have a good day, everybody. Bye-bye.
Thank you. Moving on to application number 12. Application number 12 has to do with 6117 James Bell Drive.
Mr. Chair, sorry, just on the last one, I just want to confirm for the record that we've approved both the consent application and the minor variance application, correct?
Yes, we did vote on both those items at the same time, and both were approved. Thank you, Mr. Revert. Mr. Price, application number 12 is yours, 6117 James Bell Drive.
Yes, good morning, Mr. Chair.
Good morning. Can you take the oath for the sign posting on your property today?
I most certainly can.
You solemnly swear or affirm that the notice provided by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing as instructed and was clearly visible and legible during that time. Do you swear?
I swear, Mr. Chair.
Thank you very much. Can you give us a brief description then on your application today?
Absolutely. Thank you, Mr. Chair. Again, Rod Price on behalf of the owners at 6117 James Bell Drive. Before you is an application for minor variance, one for a reduced setback from the water course of 23.7 meters, where the minimum setback is 30. And the second variance is for an increase in lot coverage to 18.88%, where the zoning bylaw permits 15%. I'm going to preface I'll try to keep this brief. I'm going to preface my comments and my presentation in that we are aware of staff's objection as it relates to the coverage variance. One thing I think that needs to be considered is staff have been instructed to apply the most stringent of the two policies, whether that be the old official plan or the new official plan. And in this case, staff are interpreting the new official plan as it relates to the lot coverage variance, and that they're objecting to the variance based on not having 800 square meters of allowable space for the septic system. So to be clear, prior to moving forward, the new official plan has been adopted by council. It has not been accepted or approved by the Ministry of Municipal Affairs. Therefore, when considering the application, although staff are instructed to comment and provide their report based on the more stringent of the two, in terms of committee's purview, in terms of making a decision on these variances, the old official plan policies are to be considered, because those are the laws of today while the application is being considered. So in that regard, I understand staff have applied the 800 square meter provision, the new policy in the official plan, and are therefore objecting to the increase in the small lot area that is proposed. One thing to take into account, in terms of the existing lot area, there's also an additional 1,000 square meters that the owners lease from the Crown that abuts the Rideau River. Unfortunately, through pre-application consultations, that portion of the lands, although enjoyed by the owners and serves both ecological function and as actual coverage, it cannot be considered for the legal lot coverage. So therefore, the actual variance is closer to 17% as opposed to the 18.8. But as per the zoning bylaws and the interpretation, it's an increase of about 3.88%. We have shown through additional information that have been provided to staff. A planting plan has been put in place with the Conservation Authority. The septic permit has actually been issued to the owners based on what they see in the criteria to issue that permit. So in terms of your consideration as a committee, we are of a firm belief that the 3.88% meets the 4 tests in that it meets the intent of the current official plan and definitely meets the intent of the zoning bylaw with respect to permitted uses. It's consistent with what's happening in the neighborhood. So we're quite comfortable in that, based on the policies of the day that are in place and should be considered by committee, the request for that coverage increase is quite minimal. I know there's some discussion in staff's report about an EIS. Again, the policies of the day are that we are to enhance the property, which we have, by way of a planting plan with the Conservation Authority. We've moved the house as close to the street and far away from the water course as humanly possible. It's no further than the current dilapidated cottage that is currently on the site. All the trees in the rear yard are to be retained, and there'll be minimal disruption in that new setback from the water course. And I don't believe staff have much of a concern about the setback so much as an EIS. But in this instance, given that a planting plan has been issued and begun to be implemented by the owners along the shoreline, it meets that requirement. So happy to answer any questions that committee may have.
Thank you very much. I'd now like to ask Mr. Harrigan to make some comments on behalf of the city.
Thank you. Through you, Mr. Chair, the planning department, in summary, has concerns with the watercourse setback, but we do object and would like to see the increased lot coverage refused. This application, this property is in a little bit of a tricky situation because there is the watercourse setback pushing from one side and then the septic system issue pushing from the other side. As regard to the comments about the new official plan, this is city council approved. It has been passed by bylaw. We do need to implement it. The new official plan is being implemented across every single committee, planning committee, ARAC committee, rezoning application, subdivision application, condominiums. Almost every single application is being applied under the new official plan. There's very, very limited cases where we have under the old official plan, and that has only been for consent applications because the new official plan just doesn't permit them currently with the current mix up in the wording. And in this case, it's not appropriate to go to the old official plan because this is directly an issue of public health and safety in this matter. And I will go into that a little bit more. So first, I'd like to talk a little bit about the watercourse setback. And as mentioned for previous applications, the new official plan affords a significant deal of protection to water features. They have been identified as one of the most valuable resources that we have for fighting climate change, erosion protection, just the quality of living, ecological features and functions, and they are to be protected even if this means limiting or restricting development. One of the first criteria for the watercourse setbacks is for permitting development within a watercourse setback is demonstrating that the area outside the watercourse setback is impossible to house all development. And in this case, that was one of our concerns with the first adjournment request. Mr. Price has worked with the city, provided us information about the area outside of it, and we are satisfied it's impossible to adhere to that setback entirely, and we do recognize that. The second part of that watercourse setback is if it is impossible to adhere to it, as is the case for here, we have to demonstrate that the ecological features and functions of the site are restored to the greatest extent possible. Now, we had an initial adjournment request. We had noted that based on the images that we had seen, that a considerable amount of vegetation was to be removed and there just wasn't additional planting. Again, Mr. Price has been fantastic and provided us with more information, demonstrating that no additional trees will be removed except potentially just one at the front of the lot line for a new driveway. But then they also have worked with the RVCA for additional plantings along the back slope near the watercourse, which would be kind of the most, which was the most ideal to have planting there. The department still has some concerns just because there's potential for erosion in this area, and an EIS would confirm what is the state of erosion, the ecological functions of some of those plantings, and just the natural enhancement and restoration of that. They are proposing an increase in lot coverage, which will cause more runoff and erosion, and having an EIS to that regard will kind of ensure that that erosion protection, those ecological features are enhanced to the greatest extent possible. An EIS has not been provided at this time, so we don't know exactly what those ecological features and functions are, but we do know that there has been plantings that have been or will be done. So we do know that some erosion protections have been provided. It's just that the policy requirement to the greatest extent possible. Now, in regards to the septic system issue, there's a policy in the new official plan that says you require 800 square meters for the septic system as undeveloped area, and this is meant to house the septic bed. This policy is a new policy, and I have had the opportunity to follow up with the policy team, the senior risk management officials, as well as the hydrogeologist for exactly why this policy was created. And in fact, it was created specifically for properties like this. There's a current issue with the Building Code of Ontario and the Septic System Office, where for lots like this, they can go and they can buy and get a permit for the smallest septic system possible and put it on a very small area for this lot, and that will serve an increased lot coverage, more housing, more people living there, and they can go and can get their permit. That's exactly what Mr. Price has demonstrated. They have their Ottawa Septic System permit right now for a very small system, the smallest system that they can possibly get. Our issue, and this has come directly from the risk management office and the hydrogeologists, is that those systems fail in 10 to 15 years because they're overburdened. It is such a small system, and there's no way for the Ottawa Septic System Permitting Office to catch those mistakes, or for the Building Code of Ontario. They just don't have the right regulations in play to account for these future failures in 10 to 15 years. Our official plan does have the opportunity to do that specifically right now. And really what it's saying is this will be an issue of public health and safety in approximately 10 to 15 years. And given that the septic system is already about 15 meters away from neighboring wells, this will cause an issue of potential contamination, public health and safety. This policy is made specifically for these lots. These areas have already kind of been built up. They have such small septic systems in small area. You have a lot of development in such a very small area. And now we have applications like this where they are coming in for increased lot coverage, and it's eating away even more so into that 800 square meters. Really, any increases to lot coverage aren't supposed to be supported or approved unless they can meet that 800 square meters, because that guarantees that issues of public health and safety can be resolved, or that they just won't be a considerable issue to neighboring properties. We understand that going from 15% to 18.8% is fairly minor in nature. It does follow the existing kind of built fabric in the area around it. We completely acknowledge that, but this policy has been in play because these existing developments, this existing built form is causing direct issues with public health and safety. It's something that we absolutely cannot support. We can't support any increase to lot coverage because it's going to further risk public health and safety. And that's essentially where we're coming from. We are sympathetic that, previously under the old official plan, this might have been approved, but this new official plan has it's directly related to these deficiencies in the Building Code of Ontario and the Septic System Office that is directly resulting in public health concerns. And it is a very messy thing when a septic system fails, and we need to guarantee that we have the space to adequately handle any of these potential failures.
Thank you, Mr. Harrigan. Any comments, Mr. Price?
Yes, thank you, Mr. Chair, and I do want to thank Mr. Harrigan for meeting with us and being open-minded with respect to this application. And I sympathize for staff's position when there is a transition from one official plan to the other. The fact still remains that the new official plan has not been approved by the Ministry of Municipal Affairs and Housing. And all those staff have been required to comment and provide their opinion based on those new policies. I completely respect that, understand. the fact still remains that official plan is not officially in place until such time as the minister signs off on it. That will not be probably until mid to late this fall. There's many applications, and I'm sure there's decisions being made based on the new policy. I'm sure many of which will end up at OLT for review. But in terms of speaking to for legal advice from municipal lawyers, and others in the industry, and just the way that the system works, the official plan, albeit council endorsed, is not in place in terms of making decisions. The minister has not signed off on that document, nor have they even provided comments back. We don't know that this proposed policy that staff are claiming is to protect public health, albeit probably true, could be true. Does that supersede the Ontario Building Code? Does that take the powers from the septic approval agencies out of place? So, again, respectfully with staff, and I understand the position that the planners are in with the fact still remains that official plan has not been signed off by the ministry. And until such time, those policies aren't legally in effect.
Thank you, Mr. Price. I'd like to ask our conservation partners for their comments.
Yeah, thanks. If I may, through the chair, the Conservation Authority has reviewed the application with regards to the reduction of the watercourse setback. There was no objections to the application, given that the location of the building was maintaining essentially the existing setback and wasn't encroaching further than what was existing. With the expansions to the size of the dwelling being pushed to the area outside of the watercourse setback, and that's where primarily that increase in lot coverage was being handled. Based on the development envelope, the property is outside of, or the new dwelling is outside of the regulated area, so there is no permits required for the structure. There was plantings that were installed, and through site visits, they've confirmed that they are planted, and ongoing monitoring, making sure survivability of those plantings as they grow up are maintained. But the renaturalization efforts have begun. So at this point, the Conservation Authority has no objections to the application as it's proposed. And then we would defer the remaining comments to Mr. Harrigan as he's been presenting them.
Mr. Lalonde, do you have any comments with respect to the septic system that they're proposing?
So the conversation that's been happening regarding the septic system permit approvals are accurate. The Ottawa Septic System Office has issued a permit. Their requirements are to review it under the building code, and whether a building code permit can be issued or not. That has taken place. With regards to the Hydro G component, the Conservation Authority for these types of applications has deferred. So the groundwater component has deferred that review to the city as part of their process. So as I noted, we would leave that conversation to Mr. Harrigan for this application.
Okay, thank you. Mr. Harrigan?
Thank you. I was just going to make a few comments to you, Mr. Chair. The first I would just note is this policy isn't superseding or overturning the Building Code of Ontario. It's an added protection. The Building Code of Ontario specifies what is permitted under the current septic system design, and the official plan, when you go in for an minor variance application such as this for increased lot coverage, we are allowed to have enhanced considerations for these issues. And this is exactly what is happening right now. Really, we need to get as much space as possible for the septic system to ensure that issues of public health and safety are adequately addressed and that mitigation measures are in play for that. To Mr. Price's comment about the transition policy, this is directly from City Council. They have passed it through bylaw, and it is applying to every single application citywide. I can understand his comments about the minister approval not yet being in place, but using that as a justification to sidestep issues about public health and safety just don't seem appropriate at this time.
Thank you, Mr. Harrigan. I'd now like to ask panel for their comments or questions. Ms. Chandler?
I don't have any issues with the setback. I'm happy to hear that the planting is being done. I don't think riparian Erosion issues are a concern. The site plan shows gabion baskets that, in addition to the planting on the Rideau River, would seem pretty sufficient to me. I am absolutely baffled by statements relating to these septic systems failing in 10 to 15 years. EcoFlows have been around for more than 20. They're tertiary treatment systems. Beds can be dug up and replaced, as can treatment units. I am usually concerned about lot coverage when it relates to waterfront properties, but I do defer that concern to the CA to use their judgment. And so in this case, I would support the application.
Thank you, Ms. Chandler. Mr. Otto, any comments?
Nothing further. Similar feelings in regards to the septic system. I firmly believe that if they failed in 10 to 15 years, they wouldn't be on the market anymore. So I'm in favor of this application. Thank you.
Thank you. Mr. Lewis?
Not to prolong the discussion, I support it too.
Thank you. Mr. Vervoort?
Yeah, just a couple comments. I think it improves an existing situation. I believe it meets the 4 test. It's minor in nature. The increase in the dwelling size is very limited in this particular case. I think it maintains the general intent and purpose of the new official plan and the existing one, and the general purpose of the zoning bylaw. I also note for the record that the applicant submitted a petition signed by 19 residents in support of the application. So I think overall, in the circumstances of this case, I'm in favor of the application as well.
Thank you, Mr. Vervoort. I'd like to ask the panel for approval of this application. All those in favor, please raise your hands. Your application is approved, Mr. Price. Thank you.
Thanks again, Mr. Chair. And just quickly, thank you to Eric and his team and planning staff as well. We appreciate the engagement in the last couple of weeks. It's been fantastic.
Thank you.
Thanks.
Now moving on to application number 13. This application has to do with 23938 Line Road. Mr. Pence, are you available?
Yes, I am. Good morning, Mr. Chair.
Good morning. Are you able to take the signposting oath this morning?
Yes, I am.
Do you solemnly swear or affirm that the notice provided by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing as instructed and was clearly visible and legible during that time? Do you swear?
Yes, I do swear. Thank you.
Thank you very much. Could you please give us a brief description of your application today?
Yes, we did prepare a brief PowerPoint presentation that can be displayed, but essentially what this application is about is to do a lot addition to sever a portion of the property that I guess originally there were 2 separate parcels that had merged inadvertently on title. And so the application that was submitted was to sever. Oh, there we go. There's the PowerPoint. If we could just go to the next page, please. And maybe perhaps to the next one as well. Yeah, so there you see the application for 2 parcels, the piece in green being the retained piece and the piece in red, which is approximately 39 hectares to be severed and added to the parcel to the south shown in orange, known as 2520 9th Line Road. So this application was filed as a straightforward lot addition application, and it came before the committee on June, a couple of weeks ago. I think it was on June 1st or so, and it was adjourned due to some concerns from the Conservation Authority and from city staff with respect to a potential building envelope and safe access to that building envelope from the 9th line, or sorry, the 8th line rather. If I could go to the next slide, please, to illustrate that. On that slide there, you'll see that the retained piece of property has a significant amount of floodplain on the property, and there was concern that access to that building envelope was not available, as there's about an 80-meter section from the 8th line that would have to travel through the floodplain in order to get to that building envelope. So we accepted the adjournment request, and subsequent to that, we did some survey work. And if I go to the next slide, please. This is the result of some survey work that was done to more accurately delineate the floodplain line based on the floodplain elevation provided to us by the Conservation Authority. And you'll see that heavy red line is the floodplain line that approximates the floodplain line shown on the City of Ottawa zoning bylaw schedules. And you'll also see that there's that little section of laneway that travels from 8th line through the floodplain to that building envelope. What the survey has confirmed is that there is an adequate area of approximately 1 hectare that is outside the floodplain and within the property, and that the 80 meters or so section of laneway that travels through that floodplain, it does in fact meet the safe access requirements. So I believe that we've demonstrated to the satisfaction of both the city and the Conservation Authority that their concern has been resolved. And so I'm able to answer any questions from the committee with respect to that, but that's a brief summary of our application.
Okay. I note that there are 3 conditions from planning and 1 condition for Conservation Authority. Should the panel approve this application? Are you aware of those conditions, sir?
Yes, I have. I've reviewed those conditions and am satisfied that those are appropriate.
Thank you. And as I said, I don't note that there are any comments from our conservation partners. However, I do note that we have 10 speakers registered to speak today. And I note in summary of their written comments that they're kind of almost all the same. And I want to just see if there is one person that could deal with making these comments. And I also wanted to note that we're dealing with a lot line adjustment here. We're not dealing with anything having to do with rezoning or the use of the property today. So to that end, I'm going to call on Joan Evan Daly to see if she would like to make the comments on behalf of the group. Ms. Daly, are you available? I don't see Ms. Daly there. Madam Coordinator, is Ms. Daly there?
Mr. Chair, no, I do not see her online.
Okay, thank you. Is there someone else who'd like to speak on behalf of the group? Mr. Whittle?
Thank you, Mr. Poulin. I prepared a presentation today. I hope that that would be visible to everybody.
Madam Coordinator, do you have that? Perfect. And just one note, Mr. Whittle, there's only a 5-minute time constraint that you have.
I understand. And
okay.
Thank you for hearing me today. And my name is Chris Withnall. I'm a resident of 9th Line Road. I'm here this morning representing other residents of the Metcalfe area, as well as the Metcalfe and District Citizens Association and the Community Association. And note that there was an accompanying letter that has more detail as to this presentation, which we submitted on June 1st. Next slide, please. So the parcel of land at question is shown here in green. And part of our concern is that this land was previously severed into two other parcels were severed from it back in 2016, effectively taking one parcel, turning it into 3. We now understand that this is being severed yet again into a 4th parcel, and we don't fully understand the distinction between a lot line adjustment and yet another severance. However, we'll defer to the committee's expertise on that matter. You'll also note in this image the mineral reserve zoning that passes across the Rats parcel into a neighboring parcel, which was sold recently by Sean McDonald to West Carleton Sand and Gravel late last year. And our concern, of course, is the proximity of this zoning to the Metcalfe civic boundary, which is only 600 meters away on this image. Next slide, please. So we understand this committee does not referee land sales. We know that you don't approve or reject to whom someone sells their land. And we also understand that this is not an application for rezoning, but we need to get it on record that because this is the first public disclosure of the intent to sell for sale to West Carleton Sand and Gravel, and the stated intention is to conduct aggregate operations effectively put a quarry there. We've been advised that it's important to state our opposition to this immediately and categorically, which is what we're doing now. And of course, a quarry on the Metcalfe border is inappropriate for a ton of reasons, not to mention it does nothing to benefit the quality of life or the property values of the residents. We don't have roads suitable for this. Most importantly, of course, that the residents of Metcalfe, myself included, rely on the quality and supply of well water. And we know how detrimental quarries can be to that effect. Not to mention the environmental implications, the ecological implications, groundwater contamination, all the things I was very pleased to hear Mr. Harrington previously speak about with regard to a septic system. So if a septic system is a problem, we certainly hope a quarry is going to be a problem too. Next slide, please. So this is an image of the Metcalfe area. You can see Metcalfe in the lower right corner and the mineral reserve zoning highlighted in blue. In a 12-kilometer square, I counted 27 existing quarries. We have a lot of quarries in the Metcalfe area. We feel that we do not need any more. And this is a position that was presented to the city by the Citizens Association a few years back, who agreed there was already a 100-year supply of material already present, and we don't need more quarries. Next slide, please. So how did we get to this point? We were quite surprised to learn that this area was in fact zoned as a mineral reserve, and especially in light of a letter that was sent to some homeowners back in 2013, which stated that bedrock analysis has determined that some lands within 500 meters of your property have potential to be considered as a mineral aggregate resource area. And that if anyone objected, the city would not proceed. Well, it seems they have proceeded, and it seems now that land sales have happened because of this. How did we get to this point? We know that back when it was Osgood Township, it was a marginal resource area, basically good for a lot of things, but not necessarily agriculture. It was later reclassified as a limestone resource area. And then sometime around about 2008, we understand now, it was designated with new zoning of mineral reserve. And the 2013 letter that I mentioned suggests that this wouldn't happen if residents didn't want it to. Well, we know some residents did object. And we also have since learned that these changes were made within the city without public consultation and without political consultation. It was not put to a vote at any time. So, of course, we are outraged by this, and we certainly hope that the city will take this into consideration as this moves forward. You haven't heard the last of us. We understand that there will be, at some point in the future, a proposal for rezoning to mineral extraction, at which point we will voice our protest once again. And we certainly thank you for hearing us today.
Thank you very much for your presentation, Mr. Whitfell. Now, I'd like to ask our panel for any comments or questions that they may have. Mr. Vervoort.
Thank you for the presentation, Mr. Whitnall. That was well done. However, in this particular case, we're only dealing with the lot line adjustment itself. So the committee's role in this particular application is very limited. So I think that's probably a fight that'll happen another day possibly, but in my opinion, the matter before us, I don't see any reason for refusing the requested lot line application.
Thank you, Mr.
Adjustment application, sorry.
Thank you. Mr. Lewis, any questions or comments?
No questions, comments.
Thank you. Mr. Vervoort, sorry, Mr. Otto.
No questions or comments. I agree with what our former colleague said, Mr. Vervoort.
Thank you. Ms. Chandler?
Two short things. Just for the assurance of the public who are in attendance, if you submitted written comments, we have read them. Mr. Whitfell did ask for an explanation with respect to severance and lot line adjustment. I think maybe the short answer is when we do a lot line adjustment, we're not creating new lots. It's just changing the size of adjoining lots. So same number of lots at the beginning, same number of lots at the end. The dividing line between two lots moves. So you often that it results in two lots becoming attached and an additional lot being created. So it's equal number of lots, to equal number of lots. That's the difference. A severance creates an entirely new additional lot. The last comment would be, I think there may still be a member of the public who would like to, if they have some new information, who might like to be heard before we make our decision. But generally, I agree with Mr. Vervoort's comments.
Thank you very much. I think it's Mr. Parsons that would like to make a comment. Mr. Parsons?
Thank you, Mr. Chair. So while I don't have additional information, I think that certainly the argument between whether it's a movement of a lot line or a severance, the goal of this application is to create a severance to sell it to an aggregate company so that they can create a quarry. That is the goal. That is clear. Okay. So us voicing our objections as a community now is necessary and appropriate. And quite honestly, if this application was not approved, certainly it would be more difficult or a harder decision by Mr. Ratt to sell that piece of property to an aggregate company. This is facilitating that, which will then create a situation down the road, which another committee perhaps will have to deal with it from a rezoning. So it's getting kicked down the road by this committee. But the bottom line is that's why this is being done. That's why this application is being put forward, to sell that property to an aggregate company to create a quarry. Thank you.
Thank you, Mr. Parsons. So to that end, I'd like to ask the panel for approval of this application with all 4 conditions, 3 of which are from planning and 1 of which is from our conservation partners. All those in favor, please raise your hands. Your application is approved. Thank you very much, Mr. Pence.
Thank you very much.
Thank
Good
you.
day.
I believe that concludes our hearing for today. Thank you all very much for your help today, and we'll see you in a couple of weeks. Thank you.